morning, everyone, and welcome to today's episode on the Future of Europe, a students-only TV program. I am Leopoldine GIL, a student on European law, and today I have the chance to introduce Pauline AUFFRET, who is a specialist in all the issues related to data protection and privacy. Pauline, thank you for being here.
Thank you for the invitation. I'm very glad to be here.
Today we will be exploring several topics, notably data protection in the EU and the respect of privacy of EU citizens. Indeed, due to the quick evolution of the internet, laws were not enacted quickly enough to protect the population from the drift of new technologies. That is why data protection is fundamental in today's society. Pauline, with your expertise in the field of data and privacy, can you explain the basic principles of data protection in the EU?
Yes, well, first of all, we need to give a proper definition of the subject. So data protection, it's in its name, is about protecting any information related to a natural person, whether it is its names, dates of birth, video footage, phone numbers, you name it. Indeed, the very Charter of Fundamental Rights in its Article 8 provides that EU citizens have a right to protection of their personal data. For this very purpose, the General Data Protection Regulation was created, also known as GDPR. This regulation, which entered into force in 2016, is an essential step to strengthen individuals' fundamental rights in the digital age.
Well, this is very clear. However, it seems like a really difficult subject. Could you give your insights, for example, of the CGU, how this court does the balance between these fundamental rights, which are data protection and privacy?
Of course, for an example, I could cite the Ligue des droits humains versus Conseil des ministres, which is a judgment of the Court of Justice of the European Union dated back to June 21st, 2022, in which for the second time, the ECJ has appraised the conformity of a passenger name record system, also known as PNR, with the EU Charter of Fundamental Rights. So, whilst the court has acknowledged the legitimate objective pursued by the Directive 2016/681, which is criticized in this case, it has also emphasized the need for stringent safeguards to ensure that the criteria used in algorithmic systems for PNR data processing are targeted, proportionate, specific, and also non-discriminatory.
Can you maybe elaborate on what is the European Union's Passenger Name Record Directive, because it appears really important in this case?
Yes, of course. So, as previously mentioned, the collection of air passengers' data is an integral part of the EU Security Union strategy. So, in 2016, the Parliament, as well as the Council, adopted the PNR Directive in the wake of terrorist attacks in Paris in 2015, as well as in Brussels in 2016. So this directive creates an EU legal framework for the collection and use of passengers' personal data on flights to and from third countries. It must be specified, however, that PNR data may only be processed for the purposes of preventing, detecting, investigating, and prosecuting terrorist offences and serious crimes. Furthermore, PNR data can only be retained for a period of 5 years and must be deleted afterwards.
Then let me ask, what was the impulse of adopting this PNR directive?
Yes, so, well, as well as the issues I've just mentioned, there were many emerging challenges in the US regarding data protection. Indeed, following the terrible terrorist attacks the country suffered, it implemented stringent requirements mandating all commercial air carriers operating flights bound for the United States to share PNR data with the Department of Homeland Security. And this move triggered a clash of legal regimes, particularly with the EU's robust data protection framework, which imposed strict restrictions on the transfer of personal data outside of the EU. do hope I answered your question.
Well, thank you. Explained like that, I get why it was so necessary. However, the decision of the court can raise several questions, right?
Yes, indeed it can. And many academic circles criticize this directive because of its perceived disproportionate interference with privacy and data protection rights, which are enshrined in the EU Fundamental Rights Framework. And furthermore, concerns raised by entities such as the European Data Protection Supervisor, as well as the Fundamental Rights Agency, underscore the potential adverse impact of extensive data, PNR data use and automated profiling on fundamental rights. And well, I think I've done enough talking, and it's been brought to my attention that you yourself are writing a paper on the transfer of data between the EU and the US, which I would truly love to hear more about. So could you maybe elaborate a bit more on that? And because it seems to be linked not only with today's subject, which is data protection, but also to what maybe I just mentioned.
Well, yes, totally. Thank you for the opportunity to talk about my research. As you rightfully said previously, there's a clash of legal regimes within the EU and the US that imposes strict limitations on the transfer of personal data outside of the EU. Currently, there is no global privacy protection that could correlate with the global data flow. The EU tried to put in place some agreements to regulate this flow of data between the EU and in the US, but unfortunately it was a complete failure.
Okay, so what were the previous agreements that the EU may have put in place to protect the data of its citizens then?
Where there was two agreements, the Safe Harbor and the EU Privacy Shield, but however, neither of these two agreements were satisfactory enough.
Well, that's interesting. So could you tell me why the past agreements failed, and more specifically, why was the second one still not good enough?
Well, I will try to be brief because it's very complex. So I'll focus first on the Safe Harbor Agreement. It was born as a response to the disparities between the EU and the US. Indeed, the US companies that adhered to the Safe Harbor principles could then freely transfer personal data from the EU to the US. And the downfall of this agreement began with the Schrems I case. In this case, the CGU construed the European Directive on Data Protection standards requiring that the third country's laws must ensure, and I quote, ensure an adequate level of protection for personal data. According to the CGU, this standard requires that the third country's laws provide a level of protection that is essentially equivalent to that guaranteed within the European Union. Thus, the court found it failed to meet this standard. Now, according to regarding the second agreement, which is the EU Privacy Shield, it was meant to fill the gaps of the first agreement, as you asked. However, in 2020, the CGU again invalidated this agreement in the Schrems II case. Given the court's finding on the US surveillance laws, a future case might deem transfers to the US based on standard contractual clauses invalid because they fail to meet that essentially equivalent to that guaranteed within the EU standard.
But then, following this reasoning, the question that might arise is this new transatlantic framework really functional, and did it fill the gaps of the past agreements?
Well, first we need to analyze if the US took a measure to protect the EU citizens' data, and indeed President Biden's executive order introduced safeguards and a means for EU citizens to file complaints, for example. Following this, the EU Commission initiated a procedure to adopt an adequacy decision for the US in December 2022. Additionally, the EU Parliament noted that while the Data Protection Review Court allows EU citizens to file complaints and challenge data processing by US authorities, its structure lies clearly constitutional safeguard, then we can say that it tried to fill the gaps of these past failed agreements, but we do not know yet if the EU will allow such a framework to last in time.
Oh, well, thank you. That was very clear. It's truly a shame that EU citizens' data is endangered. And so what would you say could be the future of data protection within the EU, and what can we expect for the evolution of data protection?
Well, the future of data protection in the EU is likely to blend with European principles, but also other jurisdiction principles, such as the US, for example. The concept of accountability, which is integral to American data protection, is now incorporated into EU regulations or other rules. In addition, the EU has recognized the importance of strengthening data protection as a fundamental aspect of its future, as mentioned, for example, in the Conference of the Future of Europe in 2022. Moreover, I want to add this element. Recent developments like the implementation of the Digital Market Act 2 weeks ago demonstrate the EU's commitment to safeguarding data privacy, but also the security. We can only hope that the EU will likely continue adopting measures to protect its citizens in response to evolving technologies.
Yes, well, let's hope it is the case for the better and for the future of Europe. Thank you for this exchange, Leo. I learned a lot from you, and I hope that you learned a little bit from me as well.
Well, absolutely. Thank you for your insights and also for being here. Thank you for following today's show, and see you next week on the Future of Europe.